So I will hit the go live button. So everything after this should be live.
Thank you.
Okay, I think we're good.
All right, good afternoon, everyone. Welcome to our August meeting for the Social Work Advisory Committee. We will do the call to order and roll call. Hello, I am Andrea Perdomo Morales, and I serve as co-chair of the Social Work Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. And unfortunately, Cynthia Schindel is not with us today. Donna Honer-Quayle.
Present.
Thank you. Sarah Behrens.
Present.
Thank you. Mary Gill.
Present.
Thank you. Mike Gillette.
Present.
Thank you. Lee Ann Gingery.
I do not see her on the Zoom.
Okay, thank you. Angie Heller Workman.
Here.
Thank you. Jane Holtz Richter.
Here.
Thank you. And Catherine Reck.
Present.
Thank you. Eric Schenecker.
Present.
Thank you. Kristen Stice. Oh, was that Kristen? Sorry.
No, I don't think I see Kristen on the Zoom. So
Okay, thank you. And Robin Unruh.
I don't believe I see Robin logged in either.
All right, then I note the following BSRB staff members are also present: David Fye.
Here.
And Sammy Barksdale.
Here.
Thank you. Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting to allow the advisory committee sufficient time to cover all items on the agenda. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended, so we will be conducting this meeting pursuant to the KOMA. On July 6, 2023, we sent notice of all advisory committee meetings to individuals who had requested notice of such meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material will be posted on the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows members of the public to attend the meeting free of charge. The notice also states that if we have any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And I did check the conference call line before the meeting started. No one was on that line, but I will let you know if I hear someone beep in.
Thank you, David. The meeting is now called to order, and the advisory committee will begin its discussion of the first item on its agenda. So with that, we have agenda approval. May I get a motion?
This is Donna, and I would move to approve the agenda.
Thank you, Donna. Second?
A second.
Thank you, Eric. All those in favor say aye.
Aye.
Any opposed? Thank you. Any opposed? All right, motion carries. Agenda is approved. With that, we will move to our next agenda item, which is an updated presentation on social work multi-state compact by representatives from the Council of State Governments. I'll turn it over to you.
Great, thank you. Good afternoon, everybody. I'm just going to take a second and share my screen here. Just want to confirm everybody can see that okay?
Yes,
Yeah.
we can.
Yes.
All right. Well, again, good afternoon. My name's Matt Schaefer. I'm with the Council of State Governments here to just provide a brief overview of the Social Work Licensure Compact and give you an update on where we are at currently with the compact. And I had the privilege of speaking to this committee last year, so many of you all are probably familiar with this concept. But just wanted to give you an update today and provide a brief little overview of how the compact works and some of the particular provisions that are important to understand. So before we get into it, just a little bit about CSG. If you're not familiar with us, we're a membership organization for elected and appointed state government officials. We're headquartered in Lexington, Kentucky. We've been around for almost 100 years, celebrating our 90th birthday this year. But we work with the legislative branch and executive and judiciary on policy issues that cross state lines and promote excellence in state government. Excuse me. One program within CSG is our National Center for Interstate Compacts. So we are a technical assistance provider for the creation, revision, and enactment of new interstate compacts. We're really the only group out there that works on interstate compacts. And so we are kind of the national experts when it comes to these multi-state compact agreements. So what exactly are we talking about here when we use this term interstate compact? What we're talking about is a legal contract between states. So just as individuals can enter into contractual relationships with one another, states can as well, and these are called compacts. There's a picture on your screen there of the driver's license, which is probably the most common example of an interstate compact, which allows you as a Kansas resident to hold a Kansas driver's license and drive wherever you want in the country. That's because of the driver's license compact. So that was not a federal solution. That was states coming together and crafting their own solution for themselves. And so that's what compacts are all about, is creating solutions for multi-state problems. In recent years, professions have been turning towards interstate compacts to solve these issues around licensure portability. And so we've really seen an explosion of interest in these licensure compacts in recent years. You can see there the statistic on your screen, 289 pieces of legislation just in the past 7 years. And there's 15 professions that have these currently. And the majority of states have passed at least 3 of these compacts. I know Kansas is certainly one of those states. I think Kansas is in about 6 or 7 compacts. I'd have to check that to be sure, but I know they passed multiple. But primarily these compacts, what they're trying to achieve is the facilitation of multi-state practice. So allowing licensees to be able to practice in multiple states simultaneously without having to navigate each state's specific licensure process. So creating an optional alternative pathway to practice for people who want to be mobile, work in multiple states, or move frequently, change their residence frequently. We think that compacts help preserve public health and safety. This is largely due to the amount of information sharing that occurs amongst the member states, sharing things like the presence of investigative information or adverse actions. Sharing that information amongst the regulatory boards is really raising the bar in terms of regulation and the amount of information that regulators have access to. All of this is done while simultaneously preserving state authority over professional licensing. And this is an important point to understand, is that the compact does not dictate scope of practice. It doesn't dictate what Kansas has to require for a Kansas license. It's just the creation of this optional pathway for social workers who want to work in multiple states. So scope of practice that stays with the Kansas Board of Social Work and licensure requirements. All that is retained by the state of Kansas, and the compact doesn't dictate any of that. You can see here the list of professions that currently have these. Probably interesting for this group to note the counseling compact, which has been in existence for a few years now, has 29 member states. Psychology, a little bit older, 39 member states as well. And you can see there social work with one member state, that's Missouri, your neighbor state across the border. Missouri was the first to enact, and that was in July, just last month. So the language was just finalized in March of this year, and so it's really not a surprise that there weren't a large number of states that passed it immediately. We do have a significant number of states interested in moving the legislation next year in 2024, but for a lot of states this year it was just too late. So let's talk about some of the benefits. Obviously, the primary benefit we're talking about here is ease of mobility for licensees. So you're no longer bound to the state where you hold a license, but you can work in any compact member state. And so that simultaneously is also expanding employment opportunities as well. Telehealth, that's a big discussion in social work that we hear all the time in these conversations about the compact. And so leveraging advances in technology like telehealth, the compact is made for those types of things. And then lastly, supporting relocating military spouses. The Social Work Compact was funded through funding from the Department of Defense. So there are provisions in there about military spouses, specific to military spouses, although the compact is intended to cover all licensed social workers. We think there's benefits to the board for regulators, reduction in application processing time. You're no longer having to process as many out-of-state applications because those practitioners feasibly would be using the compact instead of needing to apply for a Kansas license. So reduction in that administrative burden, providing access to discipline information, investigatory information. That is a big benefit that I've already mentioned with these compacts, and just largely enhancing cooperation amongst the member state regulatory boards is often seen as a big benefit. States really like these, especially legislators, as a workforce development tool. So we've heard all the time about workforce shortages, practitioner shortages, particularly in the mental health care professions, and access to mental health care is a big concern for a lot of states. And the compact is often seen as a lever that states can use in order to help alleviate some of these shortages. Okay, so just to run through some terms that are important for you to understand as you're reviewing the compact. So first term here, regulated social worker. That's just any social worker who holds a license, regardless of category. So the intent here is that the compact would cover all categories of social work practice, the BSWs, MSWs, and LCSWs. So regulated social worker is just kind of the umbrella term to capture all of those categories. Home state, the compact member state where the social worker is domiciled. So that's defined as primary state of residence. Remote state is just any other state in the compact other than the licensee's home state. An interstate compact license or a multi-state license is just the license granted under the compact that allows practice in all of the other compact member states. Multi-state authorization to practice. This is the legal authorization for you to practice in a single remote state, and that is the thing that the remote state has jurisdiction over. So if I'm a Missouri multi-state license holder and Kansas is in the compact, I have multi-state authorization to practice in Kansas, and that's the thing that Kansas can take action against if I violate Kansas's laws. And we'll talk about a scenario, a discipline scenario later to kind of flesh this out a little bit more. And then lastly, the Compact Commission is just the governing body that made up of all the member states that are responsible for administering the compact. So how it works, a social worker holds a unencumbered license issued by their home state. They apply through their home state's licensing board for what is called the multi-state license. The home state is the one that verifies that social worker is eligible, meets all the compact's requirements, and then issues based on their the previous single state license that they held. So if they're a BSW, they would have a multi-state, a bachelor's multi-state license. If they're an MSW, they would have a master's level multi-state license. And so the multi-state license is issued corresponding to the category of licensure sought by the member state. And now that social worker has legal authorization to practice in any remote state that's in the compact through that multi-state license. So most of the administration of the multi-state license is done by the home state licensing board. So some of the key provisions that would be important to understand. So Section 3 outlines the state requirements to join the compact. This is not what the social worker has to fulfill. This is what the state has to have in place in terms of licensure requirements. So the state has to license and regulate one of the following categories: bachelor's, master's, or clinical. So it's not saying that you have to regulate all three, just one of the three. I think every state regulates clinical, so no state should be ineligible based on this provision. Require that licensees graduate from an accredited social work program corresponding to category of licensure sought. So that's BSW for the bachelor's category and MSW or higher for master's and clinical. Require that multi-state license holders pass a qualifying national exam. So the qualifying national exam is essentially defined as an examination, a national licensing examination approved by the Compact Commission. And currently, the only national licensing exam out there is the ASWB exam. So for all intents and purposes, when you see qualifying national exam, you can think ASWB exam, but we use this kind of broad term just in case there is some sort of new exam developed in the future that states start using for licensure. It's not great practice to actually name specific exams or accrediting bodies or entities like that into a statutory compact agreement that we're hoping can be flexible and change with the evolution of the profession over the next 50, 70 years. And so that's why we use this kind of broader term, but for all intents and purposes, there's only one national licensing exam right now. So that's what's required in the compact. And then lastly, require that clinical social workers complete a period of supervised clinical practice. The state also has to notify the commission of any discipline actions taken, comply with rules of the commission. They have to undergo a background check process for people seeking a multi-state license. So not all Kansas licensees, but just those that are trying to use the compact. And then lastly, participate in the data system. So the compact will have a shared data system amongst the member states that they will be feeding information up into, and that's how all of the member states communicate with one another and kind of share what's going on in their state in terms of any discipline actions and things like that. Eligibility requirements for social workers. So there's three main buckets here. Competency requirement. This is on the licensee side. So we're moving away from what the state has to have in place. So licensees have to either pass a qualifying national exam, have a period of continuous licensure for those licensed prior to their state's adoption of the ASWB exam, or the substantial equivalent approved by the commission. So if you were licensed 20 years ago, your state's only been using the ASWB exam for, let's say, 10 years. We didn't want you to be prohibited from using the compact. And so that's why this period of continuous licensure satisfies this competency requirement. Again, accredited social work degree, master's, MSW for master's in clinical level, and BSW for the bachelor's level. And then for the clinical level, there is a practice requirement that is 3,000 hours or 2 years, or the substantial equivalent approved by commission rule. So that's kind of the prevailing requirement out in the states is 3,000 hours or 2 years. That's where the most uniformity was. And so that's why that's named in this particular section. So other requirements that social workers have to fulfill: they have to have a license issued by their home state, like I mentioned, pay fees related to the application, complete continuing competency requirements in the home state. So you don't have to do CEs in all the remote states, only the home state. And then lastly, agree to abide by the laws and rules and scope of practice in the state where the client is located. So that's what scope of practice is dictated, is where the client is located when the services are rendered. So if you're a Kansas licensee and you're seeing a patient in Missouri, you have to abide by Missouri's laws and rules when you're seeing that patient there in Missouri. Okay, so remaining section 5, which I'll talk about on a later slide, but essentially if you're moving between compact member states, there's an expedited process for you to get a new multi-state license. Section 6 deals with the kind of reaffirms what is under the purview of the state licensing authority and what's under the purview of the compact commission. And I actually misspoke. Section 7 is about the reissuance of the multi-state license. Section 5 gives the boards a little bit more guidance as to how, because we're dealing with different categories of licensure, different licensure levels, and not all states regulating the same levels, there's just a little bit more guidance in terms of the actual issuance of the multi-state license. So I talked about there are provisions in there. What if you actually want to move? So we've talked about how the compact makes it easier to practice in multiple states. If you want to move, there is a section in the compact that allows you to essentially exchange one multi-state license for another. The new home state will require a background check and completion of any jurisprudence requirements in that state, but essentially it's like a swap. You would take your Kansas, if you're moving from Kansas to Texas, you take your Kansas multi-state license, tell the board you're moving, they will expire that license, and then Texas will issue you their equivalent multi-state license. So remaining sections, like I said, there's provisions for active duty military, which allow them to designate a home state and retain that home state designation throughout their active duty military service. Adverse action, I'll talk about that on a later slide. The Compact Commission, again, is just the governing body that oversees the compact. It's made up of the member states, and we say that the commissioner from each state shall be a representative of the state licensing authority. So that'd be the Social Work Board in Kansas. And then lastly, Section 11, the data system. Again, I've talked about the data system, but allows the member states to communicate with one another, share information about licensees using the compact, things like adverse action and availability of investigative information. Okay, so I just want to run through a couple examples of how the compact deals with discipline. This is a common question. So that is found in Section 9, where it talks about adverse action. So in this first scenario, the social worker violates the Practice Act in their home state. So the home state takes an action on the multi-state license, and their ability to use the compact is automatically suspended. So if the home state takes any action out of the compact until that multi-state license is restored to good standing. So they're no longer able to practice in remote states until that home state restores their license completely. If they violate the Practice Act in a remote state, that remote state takes the lead on conducting the investigation. If the remote state takes an action on the authorization to practice in their state, that information is shared with all the other member states, and they can choose whether or not they want to take a reciprocal action on their authorization to practice. So the principle here is the remote states can't take an action on the license itself because they didn't issue it. If somebody has a Kansas multi-state license, Oklahoma can't take an action on a license that Kansas issued, but they can say, we don't want you practicing in Oklahoma anymore. So that's the principle here is each remote state retains control authority over who's practicing in their state, but only the home state can actually take an action on the license itself. I wanted to just talk a little bit about the commission. There's a lot of confusion out there about what the commission is, who the commission is. So again, this is just the governing body that administers, implements the compact. Every state gets to elect one person to sit on the commission. The rules of the commission are limited to the implementation of the compact. So it's not possible for the commission to dictate things like scope of practice or licensing requirements. And the rules also don't apply to licensees outside outside of the compact. So just your regular Kansas single state license holder is not going to be impacted by any of these rules of the commission. So those rules would be null and void if the commission ever tried to write a rule that would impact somebody outside of the compact or impact a state outside of the broad terms of the agreement. So that's all the compact commission is authorized to do. Remaining sections here, and then I'll wrap up and take some questions. So the commission does have rulemaking authority, like I just mentioned. This is just to allow the compact to be flexible. If we had to change the statute every single time there was a change needed, that would be a very cumbersome process to have to reenact that statute every single time there was a change. So we give the commission rulemaking authority so that they're able to be more flexible and make changes in the future in an easier way than having to get a bill passed again. There's a dispute resolution process if there's out of compliance states to bring those states back into compliance with the terms of the agreement. The effective date we say is when the compact comes into effect or comes into law in the 7th member state. So until we hit 7 states, we're just kind of in this limbo period where states are passing the compact, but we don't have any, none of this has gone into effect yet. The compact can be collectively severed if the member states chose to do so. And then lastly, binding effect of compact and other laws. This just says that if there's any conflict between the compact and an existing state law, that the compact would supersede that conflict. And conflicts are very rare because the compact doesn't dictate scope of practice, doesn't dictate licensure requirements. The chances of there being a conflict between existing state law and the compact are pretty rare. All right, here's where we're at in terms of legislation for 2023. So you can see Missouri is our single state that has enacted the compact. We had a lot of bills this year, and a lot of these they'll carry over to next year, or it was just too late to get something done this legislative session, and so we'll likely start with a new bill in these light blue states. But you can see there's a lot of interest. I would expect probably 15 to 20 states introduce the model legislation in 2024. Here's our website, swcompact.org. There's a lot of great resources there for you. You can see the live interactive map with all the bills. There's the model legislation and a lot of educational resources for you. So if you want more information about the compact, I really encourage you to go and check out that website. We just hosted a half-day meeting that was 3 hours long that we recorded. It's essentially a deep dive into the compact. And so if you want more information than I was able to provide in this brief presentation, I'd really encourage you to go to our website, and then you have my contact info there on the screen as well. And I'm happy to share these slides with David after the meeting, and he can circulate these to the committee. So with that, I'll conclude and take any questions.
Well, thank you, Matt. And it looks like before the other members of the committee have a few questions, I figured I would start with a couple that I've heard questions from people just to clarify a couple things. And then, yeah, if there's any members of the advisory committee that have questions, I appreciate you kind of answering the questions for us and helping us understand the compact better. And thanks for coming back. You mentioned that you had provided information to this group last year, and that was a really helpful presentation walking through the compact language. At the time, it was in draft form, and as you mentioned, in March of this year, it was finalized. And so appreciate all your work in this, and had a couple questions. So in terms of the compact, we have heard that there are groups in Kansas that are interested in having legislation introduced next session. And so we're kind of doing our due diligence as an advisory committee right now, seeking more information and learning if that would be something that the board should support in terms of Kansas. And in terms of the compact, you mentioned if 7 states pass the model legislation, that would be the threshold for the commission to start meeting. I imagine over time, more states will be joining the compact after that commission can begin. In terms of the model that the compact commission allows, which is multi-state licensing, where you would have each state still be able to issue a single state license, but be able to issue the multi-state license. If there are individuals from other states that are currently licensed in Kansas,
Megan.
if there's individuals that are currently licensed in other states, or they live in other states, but they're licensed in Kansas, and those states join the compact, would those individuals have the ability to still get a license in Kansas, or would they have to receive the multi-state license in their state?
Yeah, great question. So the multi-state license is completely optional if somebody just the compact doesn't prohibit anybody from just going to Kansas and getting a regular Kansas single state license. So that licensure pathway is totally unimpacted. And so the compact is just an additional optional alternative pathway if you want to work in multiple states. But if you just want a regular Kansas license, the compact doesn't say anything about that.
Okay. And then in terms of, you had a list of requirements for states to be participating in the compact. And then there was a different section, section 4, for individuals to be able to practice under that compact. I know one question that I have heard has to do with is passage of a national examination a requirement. And so it looks like from what you had in section 3, for the states to participate under the compact, they would need to require passage of a national examination. For individuals to be able to practice under the compact, it looks like in section 4, it says for them to have passed a national examination, or if they became licensed prior to that being a requirement, that would be sufficient too. And then there was some language about or substantial equivalent process as approved by the Compact Commission. I know the Compact Commission hasn't discussed that, but was there any preliminary conversation about that substantial equivalence element that you could share?
No, and that was really just to give a placeholder to the commission to approve something new if it arose in the future. I know there's been a lot of discussion over the past 18 months or so about examinations in social work, and a lot of states are kind of reevaluating their requirements, especially for those like the BSW, MSW, and in some states are looking at kind of other competency measures outside of a formal examination requirement. So these were all just kind of a hat tip to, if the commission came together and in 10 years there was some other viable competency assessment out there that a lot of states are using, they could vote and approve something like that. But there's nothing right now that CSG has in mind or ASWB has in mind that would fill this requirement. It's really just to kind of a placeholder for the commission if there was something that did arise in the future that kind of met the public health and safety standards that a traditional examination would meet.
And then you showed the map of the states where the legislation was introduced this year. I know some states have a different legislative season. In Kansas, it usually wraps up by the end of April or so. I know some other states, it could be longer in the year. So you mentioned 7 have to pass the legislation for the commission to be able to meet, and 1 state has done that so far. For the ones that was introduced this year, do you think it's likely that those states would pass, that there would be enough members passing this year for the commission to meet? Or do you think it's more likely that it would be probably sometime next year before the commission was able to meet?
Likely next year. Out of the states that I showed on the map, I think Ohio and Wisconsin are really the only 2 that have a chance of passing this year. Those other ones have either rolled over to 2024 or were not enacted and the session is over. So we're looking at probably 2 or 3 states in 2023, and then I would expect probably 10 to 12 pass it next year.
Okay. Well, thank you. Those are all the questions I had. So I'll step aside, and if any members of the advisory committee have questions, or Andrea, if you have questions, I think Matt has graciously volunteered to help us out with our understanding of this.
Thank you, Matt. Thank you, David. Any committee members have any questions?
This is Mike.
Okay, we can hear you, Mike.
Okay, I didn't hear. I was authorized to speak. Matt, you said that you're going to give an illustration, an example dealing with adverse action. So I believe that's what you said. were you still going to do that? Because I had a question on that.
Sure, and I'd be happy to kind of share again the slide that I went over that dealt with adverse action. So we can just talk about this for a second just to illustrate this a little bit more. So in this example, the social worker violates the laws in the home state. So let's say somebody has a Kansas multi-state license, they're using the compact, they violate Kansas's laws. Kansas takes an action on that Kansas multi-state license. Their ability to use the compact anywhere is suspended. So until that Kansas multi-state license is restored to good standing, their ability to use the compact is suspended. So it's kind of if the home state takes an action, you're automatically out until your license is back in good standing.
I do recall those two slides.
Yep.
It doesn't get to my question on the
Okay.
adverse action.
Sure.
Sorry to interrupt you, but don't need to. On section 9 of the compact, where it deals with adverse action, it specifically says that only the home state shall have the power to take adverse action against a regulated social worker's multi-state license.
Mm-hmm.
And so I understand that principle. My concern is if a person is practicing for the Veterans Administration in Kansas, but their license is in Virginia.
Mm-hmm.
Currently, they function under federal rules in order to be able to do that type of practice. And so the multi-state license wouldn't even apply to a federal agency. DOT, likewise, the federal laws are what regulates them on the federal facilities. But if they go off of that facility and they practice outside of that, or if there was a concern that someone would raise, they can't raise it with the Kansas BSRB. They have to take it. They don't even know where this person's license is. And so would it be through our state that would then say, yes, that person has a multi-state license, this is the state? And it says in there that the state, the home state, absorbs all the costs related to that investigation, looking for witness statements or any of the things that go along with that. I could read it for you, but it's in that section 9. And, not that I expect that to be happening on a regular basis, but it seems like that does expose a state to an obligation financially. And would our investigators somehow be able to help with another state's investigation?
Sure. So that's a great question. So just to clarify, Kansas would have the authority to take an action against a social worker using the compact in Kansas. They just can't actually take an action on the license itself because they didn't issue it. But what Kansas is taking action against is what the compact calls multi-state authorization to practice. So it's simply your ability to practice in Kansas under the compact. So Kansas can say, we don't want you to practice in Kansas anymore. And they have that right. They could say, we're going to suspend you for 6 months or put you on a probationary period or fine you or something like that. They have the authority to do that under the compact, even if that person that Kansas did not issue their license. So if somebody violates the Practice Act in Kansas, the Kansas investigators would lead that investigation. There is language in the compact about states working together collaboratively on joint investigation. So Kansas would likely be working with the home state on that investigation around that person. So I didn't want to give the impression that Kansas can't do anything for somebody using the compact, because that's not the case. Kansas retains its ability to protect
Protected citizens.
its citizens, yes, and protect the public and make sure that there's no bad actors trying to use the compact.
Yeah, it's just that when I read that, it says all the fees, the travel, all that stuff is absorbed by the home state. But that helps me to understand that, because one of our primary responsibilities is protect the health and safety of the citizens of
Right.
Kansas.
And I can get some clarification on that language that you're talking about with the cost of the investigation, because I don't think it's the intent that if a remote state leads the investigation that the home state would be obligated to pay for that. So I can get some clarification from our drafting attorneys on that language.
Yeah, it just seems that if someone's got a license in Virginia or something, and we're out here in Kansas, that could be a significant expense, it would seem, just to get some simple witness statements or, thankfully we don't have too many big issues, but if we do,
Yeah.
thank you. I did have a second question, different subject, but I want to give others a chance to ask questions.
Thank you, Mike. Any other questions? All right, Mike, if you want to ask yours.
Okay. Yeah, this is an exhaustive document, and I'm not a lawyer, and I could not read all of it in the kind of fine analysis I would like to give it. But in section 2, gotta look at my note. Section 2, paragraph M. This is kind of like a definition section. And it speaks of the issue of impairment, and it says that means a condition that may impair a practitioner's ability to engage in full and unrestricted practice as a regulated social worker without some type of intervention. It may include alcohol, drug dependence, mental health impairment, and neurological or physical impairments. Those impairments are not defined in here. What defines it as an impairment? And I think of physical impairment. I'm physically impaired. I have to wear hearing aids, hearing assistive devices to do anything practically other than using my earbuds where I can control the sound. I think the sense in which our state or Kansas has a similar type of a language that says something to the effect that if a person is involuntarily, I don't have the quote to our statute or to the regulation, but we have a way to, if a person isn't fit to be able to practice, that they're not able to practice, that type of thing. So how's this compact with this definition of impairment? Neurological, if they have Parkinson's disease, they aren't able to practice. I would think that wouldn't be true. But if they had a stroke and they were not able to function, they might be able to speak, but not function in an adequate fashion. Somehow, I don't know how the compact would be able to even look at this, but I can understand how the states do. And then with mental impairment, many people have different definitions of what mental health impairment could be. And they can make a distinction between mental illness and mental health. And so you talk about depression, which is a very common type of an issue, generalized anxiety disorder, major depressive disorder. And to say that no therapist, no counselor in this compact is going to experience times of seasonal affective disorder or generalized anxiety disorder or possibly major depressive disorder, I think would be naive to think that that would be true. But, so I don't know what they mean by, now, if they were involuntarily submitted to a psychiatric hospital for psychosis or something like that during a psychotic break, I understand it. But what if they're not in a psychotic break any longer? Are they able then to practice? I'm not sure how our state deals with that kind of an issue. But anyway, that just stood out to me. One of the things as I was reading through all these definitions.
Yeah, well, you're not the first person that's pointed out that definition and had questions about it. So I think, I mean, how the compact would handle it is the commission's rulemaking process would kind of flesh this out a little bit further. I would just say, the intent of drafting that language is not that it would be, people who are it's really meant for the really serious issues of drug and alcohol addiction and things that would seriously impact somebody's ability to practice. So that's what I can say the intent of the language is, and then the commission will write rules to kind of flesh this out further about here's exactly what we mean by impaired practitioner. And I can get you some existing language. I think SIPACT and counseling may have some language through their rulemaking process about this. So I can get that over to you all if that's of interest. So.
It would be of interest to me. And then also, I know that some states, I looked at Hawaii, I looked at some other states, and not that Hawaii has this, but some states go so restrictive as to give a list of medications. If a person is taking these medications, they're considered to have mental impairment. And one of the medications, well, many of them were SSRI type medications, including Zoloft. And the concern is the person takes Zoloft, takes Xanax. It seems a bit, I don't know, the lists seem to be written not by practitioners, but by a legislative or someone else outside. And thankfully, some of those rules didn't go into effect in those other states. But just the thought that someone could make a list and put a list of certain medications and say if they're taking these things, they're considered to be mentally impaired. And anyway, that it would really concern.
Matt,
Yes.
I have a question. Since I deal with child abuse and neglect in my field, my question is all the multi-state compact, does it, I know the home state has regulations about being investigated with a felony, but what about, because I'm the director of a child advocacy center, so what about when it's under the investigative piece and they haven't been charged yet, but they are still under that investigative and it's basically gone up to a district attorney or county attorney, whoever? Is it our home state's laws then that supersede the multi-state? Because I have a case right now that's multi-state involved and they were having to report to all the states, but it hasn't gone through court yet. It's just been charged out on abuse and neglect. So how do we protect that? So
yeah,
that
and so just to clarify, the compact is really dealing with licensure discipline. If it's a criminal matter, that's completely up to the home state that's issued the license, and there's really the compact doesn't have any kind of governance over that. The compact just strictly deals with license discipline, but yeah, anything criminal that would just be with the state.
with the state, which we are already within those regulations.
Mm-hmm. Yeah.
So, okay. Thank you.
All right, great questions, Mike and Jane. Thank you so much, Matt, for making yourself available and providing us these updates. We are very appreciative of your time. And I'm sure we will love to have you back as we gather more information into next year.
Absolutely. Thank you all.
Thank you. Have a great day.
You too. Bye.
All right. So going back to our agenda, the next thing on the agenda item was review and approval of minutes from the previous advisory committee meeting, which was held on June 19th, 2023, and this should be available in your packet. If I could get a motion for approval when ready.
I will make a motion to approve.
Thank you, Jane. A second.
Second.
Thank you, Donna. All those in favor say aye.
Aye.
Thank you. Any opposed? All right, motion carries. The June minutes are approved. Thank you. Next, we have the executive director's report. Turn it over to you, David.
Thank you, Andrea. So things have been very busy here in the office. I will try to condense this as much as I can, but just there's been a lot of different topics. I want to make sure you're informed about those as well. So first, in terms of some BSRB operations, we've been working on a number of annual responsibilities here. All state agencies have to do about 15 annual reports as part of the state auditing process. So those were all completed on behalf of the agency and submitted. Additionally, each year we are asked to revise a 3-year IT plan with the governor's office. And so just to let you know, last year, some of our goals were to replace or improve the camera equipment in our boardroom to have more hybrid meetings. And thankfully, we were able to achieve that goal. So that is removed from the list from last year. We also were able to replace our projector with some of that Spark funding made available from the pandemic for modernization of equipment. Some of our continuous goals that we're working on is trying to basically convert our paper records to electronic and replace some other existing technology. Additionally, in terms of another annual responsibility, there was a bill that passed during the 2021 legislative session. It was House Bill 2066 and provided an alternate path of reciprocity for military members, military spouses, and individuals that reside in Kansas and those that intend to reside in Kansas. One of the requirements that was changed when that bill passed was beginning last September, an annual report needs to be provided by different licensing agencies, including the BSRB, to the Legislative Research Department, and then ultimately a combined report will go to the legislature, basically just looking at timeframes based on that law that passed, and also the number of individuals that were able to obtain licensure through those changes to law. So we have requested some of the data from our host of our licensing system, and we will be putting that together prior to the September 1st deadline. Additionally, some of the other operations updates during this last session, a significant bill affecting the BSRB passed. We've talked about it several times. It was 2023 sub for Senate Bill 131, and we are working on implementing a number of new items. Back at the end of June, we sent a message to all licensees listing the different items in that bill and what we were able to move forward on immediately as of July 1st, and then other items that took additional work behind the scenes. And since that point, we have been creating new applications for a lot of those different items. We have also been working with our licensing hosts to make sure that we are able to issue those licenses, which involves a lot of technical work behind the scenes, but making sure that we can send emails in terms of new license cards, making certificates when that's appropriate, and other items. So we've been testing that in a test environment and then also testing it in a live situation. And I believe before the end of this week, we'll be able to launch a few other items related to that bill. Also, in combination with some of the new license types and new responsibilities, we received permission to hire 2 new licensing specialist positions. So we have been advertising those positions and we were interviewing candidates. And I'm happy to report that we have identified 2 different individuals who have accepted the positions to take those new responsibilities. We have had some changes in our staffing here. And so we'll be advertising an additional clerical position here probably next week or late this week sometime, and interviewing for that. But ultimately, we're growing our staff by 2 members. We've also had some additional temporary staff members that we've brought in-house just to give us an influx of assistance and trying to make sure that we can implement things quickly and move forward on things. And I mentioned one of our goals was to convert paper records to electronic records. I approached the State Records Review Board last week. Every state agency has a document retention schedule on file with the state, and I requested to shorten our document retention schedule so that instead of holding license files for expiration plus 10 years, we would now be able to hold them for expiration plus 2 years. And we don't destroy them after that, but we do transfer them to the Historical Society for archiving purposes. So they approved that request, and now it is effective. And so we're in the process of basically combining 8 years of paper records and moving those to the Historical Society. The next step in September is we'll be trying to make arrangements to get approval to be able to store our records electronically. And if we get permission to do that, we will be looking to see how quickly we can take our current records and be able to convert them to electronic, which will free up space here in our office and help us with our operation. So technical, but very important in terms of our process. Additionally, all agencies have to submit a budget by September 15th. We submitted a budget last year that was approved by the legislature for this current fiscal year and also next year. And the budget we have to submit by September 15th of this year are revised changes to those 2 budget years. So I just received an email this morning that the IBAR's system is open for us to begin to put in numbers in that system. And so I'll be working on that heavily for the next month, talking to our vendors and trying to get new estimates on cost and revenues. In terms of some other items, every time the board meets, I try to keep you updated on recent board conversations. Also on board membership, at the last board meeting on July 10th, 2023, the board welcomed new board members David Stevens, who is a public member who holds the position previously held by John Norton, Linda Heitzman Powell, who's a new member for licensed psychology, previously holding the position previously held by Rick Steele, and then Deb Stidham had just completed her 2nd term. We anticipate the governor naming another person to be the new addiction counseling on the board, but the governor has not made that appointment yet. So when that appointment is made, it will be updated on the BSRB website, and I will let you know probably at a future meeting. In terms of some other items from that board meeting, the board reviewed proposed changes to regulations. Many of these had to do with fees associated with the new licenses that were put into that bill that passed this session. The bill itself establishes a fee cap that you can't charge above, and then in regulation, you need to set the specific amount for those fees. So there is information posted on the board's website and also was advertised in the Kansas Register with the Secretary of State's office, so you can review that information. Additionally, we will have a public open meeting on Tuesday, October 3rd, 2023 from 10 a.m. until 11 a.m. for the purpose of individuals providing public comment on those proposed rule changes. In terms of a few other updates, there will be some annual meetings coming up for the different associations that we work with. For the social work profession, the annual meeting for the Association of Social Work Boards, ASWB, will be November 1st through 4th. So I will be attending that meeting on behalf of the agency. Additionally, I'll be attending a meeting in September for the Marriage and Family Therapy Association with the board chair, Mary Jones, and I'll be attending a meeting for the Psychology Association, ASPPB. That'll be at the very end of September. So looking forward to those meetings and gathering information to bring back. In terms of just a couple other items, the board is interested in examining the creation of an impaired provider program. Some other states utilize this as a way for individuals to self-report if they are licensed and needing assistance with mental health or substance use issues. Other states use them as a disciplinary alternative. So if there are issues with discipline, but there are also factors involving these topics, sometimes they are able to use that as part of the disciplinary remedies to make sure that individuals are taken care of. So the board is going to be putting out an RFP looking at different options for services that can be provided. And also the board is in the process of developing an expedited license review process. There was language in that bill which authorized the board to create such a process, but not a lot of specificity. The board recently discussed that topic, and I believe they'll be reviewing some draft language at the next board meeting. And then the board once a year seeks to hold an annual offsite planning meeting. That meeting is going to be on Monday, October 23rd, 2023 from 9 a.m. to 4 p.m. in Wichita. And we'll be having more information on the specific location posted on the board's website, but that'll be an in-person meeting in Wichita. And then just a couple of legislative updates. I mentioned those proposed changes to regulations. There is a legislative committee that reviews those. They're known as the Joint Committee on Administrative Rules and Regulations, or JCAR. And they're going to be reviewing our regulations on Monday, August 21st. The meeting starts at 10 a.m. in 582 North in the Capitol. I'm not sure when we'll be on their agenda, but we'll be part of that meeting that day. And then additionally, the legislature approved a special committee on mental health as an interim committee this fall. And that committee will be meeting for 2 days on August 23rd and August 24th in room 112 North in the Capitol. They are going to be receiving some updates on mental health intervention teams, federally qualified health centers, and certified community behavioral health clinics, and also having a roundtable for some of the stakeholders. And on the second day, they're going to get updates on the 988 National Suicide Prevention Hotline, youth suicide prevention research, telehealth presentations, and agency updates based on the 2020 Special Committee on Mental Health Modernization and Reform and committee comments and recommendations. And they are authorized and approved for 3 days. So it's possible that they might meet for one additional day later this fall, or if they conclude all their work, that might be the conclusion of their work for this year. So tried to keep this a little bit shorter than normal, but want to make sure you are all aware of all the different things we're working on. There are several more items, but I think this is probably good for this meeting. And so at this point, we'll go ahead and end my report and see if there's any questions.
Thank you, David. You and your team are always busy. Any questions for David on the items he reviewed?
Real quick, the August 23rd special commission, is that going to be public? Like I could click onto it and observe it through a video link, or do you know?
Now, were you talking about the legislative meeting or?
Right, it was a special mental health. I didn't.
Yes.
It's just,
So there is a special committee on mental health that was approved to meet. It's a legislative committee, and it's going to be meeting on Wednesday, August 23rd and Thursday, August 24th. Since that is a legislative meeting, you can watch those committee meetings on YouTube. If you look for the Kansas legislature, you will get a page. And then if you go to their live broadcast, you can kind of see what the website is for that. But yeah, you can either sit in on those meetings, or you can watch them live, or you can go back and watch them afterwards.
yeah, thank you. I'm one of the weirdos that like to watch that stuff anyway. Okay.
That's great. There's a lot of good
No,
information.
that was a great question.
Yeah.
All right. If no further questions on that, we'll move to the next item, which is training for board members and advisory committee members. And
Great.
David, you're back on.
I'm back on. Thank you, Andrea. So each year, the board and advisory committees are asked to have an annual training. This is information that is based on some of the documents in your packet. There is a specific document, expectations for board members. There's also an advisory committee policy, and there is a document that has to do with some guidelines for public attendees. And then there is additionally a PowerPoint, and that PowerPoint is lengthy, so it wasn't included in your packet, but it is posted on the agency website, and I'll share that today. But if you want to go back and take a look at it, you can go to the website, and it's posted with the other materials for the meeting. But some of this, it may be more helpful for board members, but in your role as an advisory committee member, some of you, I believe, could be board members in the future. And also it's important for you to understand the role that you play within the major context of the board. So with that, I'll go ahead and share my screen here, and we'll go through some information on training. And then just make sure we manage to get through everything. If you do have questions, let's go ahead and circle back to those at the end of the training. So you should be able to see my screen here. This is the training for the BSRB, training for board members and advisory committee members. So it's kind of a combined training. As a reminder, the mission of the BSRB, in accordance with the intent of the Kansas legislature, is to protect and serve the consumers of services offered by BSRB licensees. And that's through the issuance of license, resolution of complaints, and creation of appropriate regulations accomplished through efficiency, fairness, and respect to all those involved. The history of the BSRB is that in 1980, the Kansas legislature created the Behavioral Sciences Regulatory Board by combining the Board of Psychology Examiners and the Social Work Examiners Board together. Over the years, the BSRB's jurisdiction was expanded to include the licensure of professional counselors, master's level psychologists, marriage and family therapists, addiction counselors, and behavior analysts. Rather than have separate boards for psychologists, social workers, professional counselors, marriage and family therapists, addiction counselors, and behavior analysts, there is one board, and it's composed of professional members and public members. And this combination of individuals on one combined board is called a composite board. By utilizing a composite board model, the agency does save a significant amount of operational expenses by sharing resources and utilizing licensing and investigative staff for similar subject areas. One way to understand the role of the board is to differentiate it from an association. A regulatory board exists to protect consumers, It is created by the legislature and it is governed by statute, whereas an association exists to enhance the profession and is often created by members of that profession. In terms of the BSRB itself, we are currently 10 staff members. We're looking to grow to 12 members here shortly, but there are 10 of us currently, executive director, an assistant director and licensing manager, licensing specialist, investigators, and also clerical employees. We are known as a fee-funded agency. We do not receive funding from the state general fund, but by statute, we contribute 10% of all the revenue that we collect, up to $100,000 per year back to the state for operations. Our agency revenue is primarily derived from license fees. We have an annual budget a little over $1.1 million. And as a small agency, the BSRB contracts and has agreement with many different agencies or other entities for services, such as our licensing system, legal services, et cetera. In terms of the board, all board members are appointed by the governor to serve a 4-year term and may be reappointed for a second term, allowing service on the board for a maximum of 8 consecutive years. The board is currently composed of the following individuals, and these are identified specifically in statute for these specific positions: 2 licensed psychologists, 2 social workers, 1 marriage and family therapist, 1 professional counselor, 1 addiction counselor, 1 master's level psychologist, and then 4 public members. The 2 main functions of the BSRB are licensing and investigation of complaints or discipline. In terms of the licensees that we oversee, there are currently 15,155 active permanent licenses. Those are across the 7 professions that I have referenced earlier. In terms of the breakdown, each full board meeting, we provide a history of licensees with an updated total. And right now, these are the different levels of licensure. And so in terms of the profession that has the most members, social work has about 59% or close to 60% of all the licenses that we oversee. The largest group is the master's level of social work at a little over 4,000. And then the next highest is the clinical level of social work. But some of the other groups are also very big as well. In terms of this last fiscal year 2023 that ended at the end of June, during that time period, we issued 1,586 permanent licenses. We also issued 433 temporary licenses and 66 out-of-state temporary permits. Those numbers are slightly higher than what the BSRB issued last year. Of the 1,586 permanent licenses issued by the board, 1,124 were initial licenses, whereas 462 were through reciprocity, and those would be individuals practicing in other states that are seeking to become licensed in Kansas as well. Some of our information we're still working on pulling, but for context, I wanted to let you know some information from the previous year. So at the end of fiscal year 2022, the BSRB processed 6,214 license renewals. And as part of the license renewal process, 10% of all applicants are audited to ensure they have met the continuing education requirements. In FY 2022, the BSRB audited 625 individuals. And if you're wondering why that number is a little bit higher than 10% of the total, it's because some individuals have a mandatory audit based on disciplinary items in the past. In terms of licensing trends, since July 2015, the number of permanent licensees under the board has increased by 24.7%, from about 12,152 to about 15,155. And the professions with the largest increases are professional counseling, social work, and behavior analysis. I mentioned some information about licensing, but the other main part of the agency's responsibility is investigation and discipline against professionals. As a public protection agency, the BSRB investigates complaints against practitioners under the authority of the board. The agency has administrative authority over practitioners, but this process does not take the place of criminal proceedings or civil proceedings. We have a separate jurisdiction, and so sometimes when we get complaints from individuals from the public, if there is something of more of a criminal nature or it appears that way, we always remind them that this is not a substitution for that, and it may be appropriate for them to contact legal authorities. Additionally, some individuals come from the perspective of a civil lawsuit, and they imagine that they might be a party to this to try to recoup some sort of damages from the person. And that's not the role that we play. When someone submits a complaint, it becomes something between the state of Kansas and that individual based on the license that they hold. In terms of complaints, last fiscal year, the BSRB received 200 complaints or reports of alleged violation, RAVs, against practitioners. For comparison, practitioners received 205 complaints in FY 2022, 132 complaints in FY 2021, 199 complaints in FY 2020, and 201 complaints in FY 2019. And so with the exception of 2021, it has been pretty consistent of around 200 complaints per year. The investigators have informed me that the complexity of the complaints has increased, and so that is taking some additional time to review those cases. If you're wondering why the complaints were so much lower in 2021, I can't tell you definitively why they decreased, but that was back during some of the initial stages of the pandemic. So it possibly could be related to individuals temporarily not receiving services based on not being able to meet in person. It also could be that there was a big shift to telehealth, and there might have been some lack of clarity about what the appropriate standards were for telehealth. And so some individuals might have been happy just to receive any types of services during that time period and were unsure of what was inappropriate or what was just a different kind of normal. So basically, I can say that our numbers are consistent with other states. With those also saw a dip during that time period and then a return to normal after that period. In terms of our investigative process, complaints are reviewed to determine whether the BSRB has jurisdiction over an issue and whether the matter involves a potential violation of the statutes and regulations for the profession. In terms of complaints, they are reviewed by a subset of the board, which is called the Complaint Review Committee, or the CRC. Some of the examples of common violations include the following: falsifying continuing education requirements, which would be audit violations, practicing without a license or continuing to practice after a license has expired, dual relationships, such as conflict of interest, making sexual advances towards or engaging in physical intimacies with any client, refusing to report termination or suspension, confidentiality violations, or other practice-related issues, such as performing services inconsistent with one's education or accepted professional standards. One of the other activities that we perform here for the agency, in addition to licensing and discipline, is outreach. And so myself as the executive director, and also Leslie Allen as the assistant director and licensing manager, we speak with groups of students frequently to provide information on licensing and disciplinary matters, to provide a proactive approach to assist individuals before they become licensed. We were still pulling numbers from this past fiscal year, but in the last fiscal year, FY 2022, we provided 18 different presentations to different groups. Further, you're familiar with the BSRB YouTube channel. Back in January 2021, we launched the channel as a way to make our meetings more secure and also provide better access to all the discussions and activities and decisions that were taking place. Since that time, we have broadcast about 124 board meetings or advisory committee meetings, and those have been viewed over 4,300 times. And from my understanding, in previous years where we had only in-person meetings, I believe we had maybe around 10, at most 15 members of the public across all the advisory committees and board meetings who may have attended those meetings in a given year. And so now we are having thousands of people hear the information that is being discussed, and I'm really encouraged by that and really excited about that. And we received some additional questions based on people learning more information and wanting to be more active based on what we're putting out there. So a compliment to all of you, and happy to continue this going forward. Further, we have made an effort on the BSRB website to make resources available. The agency's website is ksbsrb.ks.gov. Some of the features on the website are, we have a portal for individuals to renew their licenses electronically, or you can still do that by paper. We have copies of all forms and other applicant materials, copies of the statutes and regulations. We link to the statutes on the Revisor of Statutes website and the regulations on the Secretary of State's website. We also have proposed changes to statutes and regulations. When the BSRB requests a bill, we put copies up there for review. When we have proposed changes to regulations, we also provide those as well, so individuals can review those and provide comment back to us if they wish to do so. We also have complaints and report of alleged violation forms for individuals to submit if there is a complaint against someone. And then there are disciplinary orders when individuals have violated the regulations or statutes. And then information on board and advisory committee meetings. We do try to post information. So any handouts you receive, you will see those up on the website so individuals can follow along if they're watching the meeting at the same time or afterwards. And now I'll transition to the specific documents that you received for the training. So in terms of documents, the board put together a document called the Expectations of Board Members. And I'll explain a little bit about the authority of that document, but that is something that board members are asked to review to make sure they're mindful of and their responsibilities. So there's a formal Expectations of Board Members policy. It's also posted on the BSRB website. The authority that document states is, insofar as the expectations for board members, if it conflicts with any limits, with any limits of any federal or state statute or regulation, the statute or regulation controls. So If there is a law and the policy is in conflict with that, the law is going to hold, and the policy is meant to be guidance after those laws and other responsibilities. In terms of guiding principles, persons in Kansas shall expect that licensed mental health providers are qualified, competent, and professional. Persons regulated by the BSRB shall expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulations. The BSRB shall provide all services in a manner that is timely, cost-efficient, courteous, and competent. The BSRB shall be guided and led by ethical principles, clear policies, progressive thinking, and strategic decision-making. The BSRB shall respect the dignity and worth of all individuals. In terms of services from the agency, we are to process license applications and license renewals in a timely manner, take disciplinary action when appropriate, to provide timely information to the public, maintain rules and regulations and statutes. The board provided information in the policy concerning a code of conduct for board members. The first item that's included there is integrity. It states that a board member of the BSRB should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. A board member of the BSRB possesses sound moral principles, is upright, honest, and sincere. A board member of the BSRB has courage of convictions to withstand pressures from being swayed from the public protection agenda. A board member of the BSRB should be honest about personal agendas and leave them outside of the boardroom. A board member of the BSRB should reveal any actual or perceived conflicts of interest and appropriately recuse themselves from decisions or actions in those areas of interest. A board member of the BSRB should not represent their personal opinion of that of the board. A board member of the BSRB should be limited to one unexcused absence per year. In terms of conflicts of interest, a board member of the BSRB should guard against conflicts of interest. In terms of compliance, common components of conflicts of interest policies include, but are not limited to, some or all the following. A board member of the BSRB should have no personal financial benefit as a result of service to the BSRB except subsistence and mileage. The board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. A board member of the BSRB should disclose any relationship with any other agency or individual involved with the BSRB and be excluded from matters involving such conflict. A board member of the BSRB serving as part of an organization working in any way with the BSRB should inform the chair. And in terms of that item there, it's understandable given the different associations and groups that you all belong to and also board members. The board does not expect that members are not going to be part of those associations. But if you are in a leadership position or you're in a role that you believe you can't have an unbiased opinion based on your role in those organizations, that is something that would be helpful to have communicated. In terms of item D, a board member of the BSRB should not accept any gifts or promotional items received as part of their affiliation with the agency for personal use. A board member of the BSRB should not use the agency's name or agency information for personal gain. And then the next item is confidentiality. Board discussion involving any of the following matters shall remain confidential unless the board expressly agrees to the contrary. Any discussion that occurs during executive sessions and any discussion concerning actual or potential litigation. In terms of the authority of the chair of the board shall preside at all meetings, appoint members of the advisory committee, appoint members of the CRC, and appoint members of other ad hoc committees. The vice chair shall discharge the duties of the chair in his or her absence, disability, resignation, or death. And there is language to allow emergency succession, but in the event that the executive director is unable to perform the duties of the office of executive director, the BSRB may request an interim director. If the BSRB is unable to meet immediately, the board chair will seek an interim director until the board can meet. In terms of the relationship between the board and the executive director, the organizational structure says that the executive director will communicate any personnel matters that should be addressed by the board to the chair of the board. And the chair of the board will present these board-related issues to the board, and the executive director will communicate to the staff the board wishes, intentions, policies, which is what we do during our monthly staff meeting. In terms of the delegation to the executive director shall be the administrative head of the organization, serving at all times under the board. The executive director will be responsible for implementing and executing the policies and activities approved by the board. He shall assist in the developing of the overall program and shall recommend policies and activities for consideration by the board. The executive director shall have sole authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to the policies, regulations, and limitations approved by the state of Kansas. And just to let you know, if we do hire someone for a specific salary, not only the person, but also the amount have to be approved by the governor's office. In terms of expectations, the executive director shall keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information. The executive director shall prepare the agenda for board meetings in consultation with the board chair. The executive director shall prepare the agenda in consultation with the board chair for the annual board retreat, which shall allow for issues before the board that need in-depth consideration. And then there's language in the expectations for board members document that identifies monitoring of the executive director's performance. It states that the board shall, when necessary, utilize executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis on whether set outcomes are obtained. And the board does use this process, such as I use it with my employees as well. We have performance reviews every year, and the board does the same for me. The advisory committees. So to assist the work of the board utilizes 7 standing advisory committees, one for each of the 7 professions regulated by the board. The advisory committee policy is posted on the BSRB website, and currently there's about 53 individuals who volunteer to serve on these different advisory committees to assist the board. In terms of the advisory committee purpose, a BSRB advisory committee as a creation of the board has the purpose of supporting the board and carrying out its mission to protect the public. Board members of the advisory committee serve at the pleasure of the board. Actions pertaining to informing, licensing, and disciplining of those persons regulated by the board are the method for accomplishing this mission. An advisory committee fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. A committee may suggest issues it believes the board should consider by referring those through the chair of the advisory committee. If an item is referred by the advisory committee back to the board has 3 options. The board can agree the issue needs to be addressed at the board level. 2, agree the issue should be addressed and refer the matter to the appropriate person or committee for additional information, review, or analysis, which will then be brought back to the board. Or 3, decide to not address the issue. In terms of the structure of the advisory committee, chairs of advisory committees are members of the board. If the profession is represented on the board, the chair of the advisory committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent that discipline on the board. Any other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. A public member of the board will also be a member of the advisory committees. There will be a minimum of 3 and a maximum of 10 additional members appointed. The executive director will be a non-voting ex officio member, and the assistant director or licensing manager is encouraged to attend those meetings. Legal counsel representing the board should attend meetings when their attendance is requested. And then terms of the advisory committees are 2 years. Members will be appointed by the chair of the BSRB and can serve up to 4 terms. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. There's language in the advisory committee that I wanted to bold and italicize to make sure that you're mindful of it. The language says the policies and procedures under which the BSRB board members are expected to operate will also apply to the advisory committee members. So there's not really a clarification of that language, but I think what is inferred by that is when you're looking at the expectations of the board members document, when you're talking about integrity, confidentiality, and those responsibilities, you want to hold yourself to a similar standard that board members are asked to follow. So that is one of the reasons why we're covering all these information together, because it does reference back to that policy. And then it does indicate here the chair of the BSRB can remove members from advisory committee members or advisory committees. When you select members of advisory committees, the document states that members of the committee may be nominated by anyone, including the public, committee members, members of the professional organization, either the discipline's own or others, and through self-nomination. In reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity. Members should provide representation of the levels of licensure for that discipline, and those members should be selected from among public and private practitioners and educators. Some other information about the advisory committee selection process. When reviewing candidates, the committee as a whole discusses nominations and reaches recommendations on new members. The committee's nominee's resume, a letter stating their reason for why he or she desires to be appointed, and a copy of the board's mission and goals to which the nominee has indicated agreement are reviewed. The chair of the committee will submit the committee's recommendations for new members to the BSRB board chair. The chair will review the recommendations and may request input before making a decision, which will be announced at a board meeting. After appointment has been approved by the executive director, the executive director will inform the advisory committee appointee by letter or email. The executive director will assist the new member by providing information which will help orient the member to the board's and advisory committee's role and function. And then you have a third document in your packet of material. This was a relatively recent document that was created to help guide members of the public. It talks about guidelines for public attendees of our meeting, and it is posted on the BSRB website. It clarifies that public comment is not entitled to individuals, but may be approved. It outlines the processes that should be followed during comments to the board or advisory committees and the topics relevant for public comment to the board and advisory committees. It clarifies the board wants to receive valid complaints against practitioners and provides information on how those complaints are to be submitted, but informs potential attendees that certain matters concerning specific licensees will be considered in a closed, standardized process to ensure fairness to members of the public and also to licensees. In terms of professional licensing boards, we're going to transition now to some general information about professional licensing boards. So in terms of the BSRB as a licensing board, the state of Kansas regulates many professions, and each of these professions is regulated by a licensing board or commission that was created by the Kansas legislature for the purpose of ensuring that licensed professionals are competent and do not pose a risk to the public. Additionally, professional licensing boards are created by enabling legislation, which establishes the board's form, mission, powers, functions, and tools of implementation and enforcement abilities. A board is considered to be a creature of statute, meaning a board's power is dependent upon its authorizing statutes, and therefore any exercise of authority claimed by the board must come from those statutes, either explicitly or necessarily implied. A board may administer, implement, and enforce only those statutes. If the statutes are silent on a particular action, the board lacks authority to take such action. Simply put, a board can only do what Kansas statutes say it can do. Besides statutes specific to a board's authority is limited by certain other factors such as constitutional equal protection and due process rights, which prohibit a board from acting in a manner which results in disparate or inconsistent treatment of persons that are similarly situated, from adopting different standards for similarly situated situations, or otherwise acting arbitrarily, capriciously, or vindictively. For example, a licensing board may not impose more severe discipline on male licensees solely because of their gender, or a licensing board may not revoke a license simply because the board does not like that particular person. Other constitutional guarantees such as freedom of speech, rights of privacy, unreasonable search and seizures, and vagueness also establish parameters for the board's authority. The Kansas legislature retains control over certain aspects of a licensing board, such as the legislature could modify our enabling legislation, which would change the purpose of the board. They could also limit expenditures in an appropriations bill. While the legislature does not provide us with funding to operate, they do establish how much we can spend, even if we have that money in a fund. They establish our yearly expenditure limitation, and we are held to that amount. They can also enact new legislation to change the makeup, scope, or powers of the board. In terms of the functions and duties of a licensing board, in order to carry out its purpose, the board is granted or delegated powers and functions that parallel the three branches of government: executive, judicial, and legislative. Under the executive authority of the board, we carry out the Enabling Act. We follow the Kansas Open Meeting Act, or KOMA, and we also follow the Kansas Open Records Act, or KORA. One of the quasi-judicial functions we have is that in hearings, we review facts when violations of law have occurred, and we follow the Kansas Administrative Procedures Act, or CAPA, when appropriate. We'll talk a little bit more about CAPA as we go through this training. We also have a legislative authority, which is more or less our administrative authority, and that is to adopt regulations to implement or interpret the Enabling Act with more detailed or specific requirements. This process involves holding an open hearing on proposed regulations, allowing feedback, and there is oversight by a legislative committee. In order to fulfill our responsibility to protect the public from incompetent, unprofessional, and unauthorized practitioners, a regulatory board implements and enforces statutes and regulations, and at times operates according to internal policies. In order to be effective, board members need to understand the differences between statutes, regulations, and policies. Statutes are laws passed by the Kansas legislature through authority derived from the Kansas Constitution and subsequently signed by the governor. Statutes generally become effective on July 1st of that session year, but can become effective if a different date is specified in the legislation. Statutes set the parameters of the board's authority. Statutes control any inconsistent regulation or policy. If a board becomes dissatisfied with the scope of its authority, for example, a board determines that it needs investigative subpoena authority, the board must seek legislation to obtain this goal. However, regulations, on the other hand, are adopted by a board to further implement or carry out the purpose of a particular statute. The board's authority to adopt regulations is derived from the statute. In adopting rules and regulations, the board follows the Rules and Regulations Filing Act to ensure that the process of adopting regulations is open, receptive to the public, and legislative input. Addresses the economic impact of the board and those affected. The regulations themselves are consistent in a style, organization, and grammar, are lawful, and are filed and published. Regulations are promulgated to complete or fill in details of a statutory scheme, implement statutes, and affect rights or responsibilities of third parties outside of the board. When adopted in accordance with the Rules and Regulations Filing Act, regulations have the force and effect of law. For example, they are legally enforceable. To be valid, a regulation must be within the statutory authority conferred to the board, implemented for a specific statute, or otherwise pass the test of legality. Any regulation that goes beyond the authority granted, violates an enabling statute, or is inconsistent with the statutory power of the board, another statute, or the Constitution will be found void. And then we've talked about statutes, regulations. The third area is policies, and policies may be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. Guidance documents are documents that state a board's approach to or interpretation of law, or general statements of policy that describe how and when the board will exercise discretionary functions. In terms of being an effective board member or an effective advisory committee member, there are some items I wanted to highlight here to help you take a next step in that role. Be familiar with the board's enabling statutes. Those begin at KSA 74-7501. Also read through the board's licensing act. There is specifically one for the social work profession on the board's website. Read through the regulations for the licensing act, and then read the BSRB policies that are posted on the BSRB website. Be on the alert for agency policies and internal procedures which may be inconsistent with or conflict with the board's statutes or regulations, or which affect requirements for applicants or licensees. While we try to be diligent about our policies, if you see something, please ask me a question. I'm happy to look into it further, and if there are items we need to update or modify, we're happy to revisit that or have the board review that as well. And be willing to initiate action to amend statutes or modify regulations. That is a really good idea. In terms of being an effective board member or advisory committee member, if a statute or regulation seems confusing or vague, it could appear that way to individuals who must comply with them. Remember, the purpose of imposing discipline against licensees is to encourage compliance with the law and to protect the public. Discipline should not be vindictive or disproportionate to the severity of the violations. Always be mindful that the role of the board is to protect the public, not the licensees. In terms of conflict of interest typically means having any interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or incurring any obligation of any nature, which is in substantial conflict with the proper discharge of the board member's duties in the public interest. A board member or advisory committee member must make public or recuse themselves from any conflict of interest that exists to ensure the integrity of the board in all its decisions. Disclosure and recusal are important tools to avoid actual or perceived conflicts of interest, but board members must not overuse recusal as an excuse to avoid conflict in exercising their full responsibilities. Personal conflicts are those actions that may ultimately have a personal consequence that is a direct or indirect effect of a decision or action. No decisions should be made that will advance the personal benefit of the board member or advisory committee member. Some of the examples of personal conflicts could include personal gain, bias, or the effects on a personal relationship. And now shifting to confidentiality. At all times, a board member or advisory committee member must conform to the rules of confidentiality and dealings outside of the boardroom. Protected information obtained in the capacity of a board member must remain confidential during and after the board membership. Termination of board membership does not dissolve the board member from responsibility. The rules that apply during active board membership continue to apply after termination of the board membership. Confidentiality must be maintained on all confidential subjects that the individual is privy to as a board member. Examples of times when confidential information could be discussed: executive sessions during an open meeting, or deliberations after a hearing, such as under the Kansas Open Meeting Act or the Kansas Administrative Procedures Act. Both of those allow the board to deliberate in private in order to reach a decision in a particular case. In your role as advisory committee members, confidential information is probably not going to come up very often, but if any information comes up and you believe that you may be confidential and you have a question, please let me know. I'm happy to discuss that with you. In terms of professional activities, board members may hold an office in a professional or trade association of the regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member must not use his or her position on the board to further the interest of the professional association or his or her office in that association. Board members may attend professional conferences and social events, but they must be mindful of open meeting rules and conflicts of interest. If a majority of board members are present, do not discuss the business or affairs of the board to avoid triggering a meeting under the COMA. Additionally, do not discuss matters related to a particular pending application or disciplinary matter. In terms of other conduct, a board member should not represent himself or herself as a spokesperson for the board unless authorized by vote of the board to speak on the board's behalf. If a board member is asked to give the board's position on an issue and the board does not authorize that member to do so, the board member must decline to comment or make clear that any opinions expressed are those of him or herself alone and not the board. A board member should not ask board staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. And then a little information here about the Kansas Open Meeting Act, or COMA. That begins at KSA 75-4317. It allows the public to observe governmental entities making decisions. Meetings shall be open to the public because a representative government is dependent upon an informed electorate. Because the purpose of COMA is to benefit the public, it is interpreted liberally and exceptions are applied narrowly to carry out its purpose. The COMA applies to all legislative and administrative bodies and agencies of the state and other subordinate groups thereof, receiving or expending and supported in whole or in part by public funds. The COMA does not define the term subordinate group, but if created by a covered entity or the group has become an extension of the covered entity, most likely the subordinate group is subject to the COMA, such as advisory committees. The COMA does not apply to an otherwise covered entity when exercising quasi-judicial functions or conducting a proceeding or hearing under the CAPA. COMA also does not apply to the judiciary, private organizations, and staff meetings of a covered entity. A meeting is defined as follows: any gathering or assembling in person through the use of a telephone or any other medium for interactive communication by a majority of membership of an agency or public body for the purposes of discussing the business and affairs of the public body or agency. And I think we'll talk about this just a little bit more, but basically, if you're ever concerned about if something is considered a meeting for the purposes of COMA, the first thing is to look to how do you have a majority of members of the committee? And then if you do, is it for the purpose of discussing items relevant to that group? And then third, is it a interactive? Is it a one-way communication, or are you having discussion back and forth? So it could be in person, it could be by telephone, it could be by email. So if you do have those things required, that meeting does need to be public based on your role as a board member or an advisory committee member. Meetings may be conducted by telephone or other electronic means, such as Zoom or Skype. If the board complies with all the COMA requirements, a meeting includes informal discussions before, after the public meeting, or during a recess of a public meeting, and all gatherings at all stages of the decision-making process. The name of the gathering is irrelevant, thus a work session or a retreat are subject to the COMA. And I did mention the offsite planning meeting in October for the board, and that's why I referenced that meeting is open to the public. And so if any individuals want to attend that meeting, they are welcome to do so, even though it is offsite and kind of an atypical meeting. A discussion does not require binding action or voting. A discussion can occur at social gatherings, retreats, and meetings held in private, educational conference, seminars, etc. Thus, when traveling to such meetings, members of the board should avoid discussing business or affairs of the agency. The presiding officer has the duty to provide notice of the meeting, but this duty may be delegated. We take care of providing public notice for all meetings for the BSRB and advisory committee. The COMA does not require notice of the meetings to be published in a paper or on a website. An individual must request notice of meetings. There are no formalities of requesting notice that can be verbal or written. The notice must provide the date, time, and location where the body will be meeting for the person requesting the notice in a reasonable time before the meeting. A request is valid for 1 fiscal year, and the board must notify a requester of expiration before terminating notice of that requester. The COMA does not address meeting procedures. A board is not required to follow Robert's Rules of Order or any other similar formal rules of procedure. The COMA does not require a board to create an agenda, but if one exists, it must be made available to everyone. A person may record the meeting if doing so is not disruptive, and the public does not have the right to speak, but only listen and observe. The board cannot vote by secret ballot. A board policy may require minutes to be kept, but the COMA does not require the board to have minutes unless there is a motion to go into executive session. The motion as made must be included in the minutes. An executive session permits discussion of certain enumerated matters outside of public view. Take an executive session, the board must first convene an open meeting. The board cannot take binding action in an executive session, but if a consensus can be allowed. If a consensus is achieved in executive session, the board must reconvene the open meeting and take a formal vote during the open session. Prosecutions under COMA are civil, not criminal. Any person, county district attorney, or attorney general may bring an action in district court. The county or district attorney and attorney general have subpoena power. Enforcement actions take precedence over all other cases and are assigned for trial at the earliest practicable date. The remedies for a COMA violation include voiding any action taken if prosecuted by the attorney general or county district attorney only, an injunction stopping the action, a mandamus forcing action, or a declaratory judgment. The penalties for a COMA violation include a fine up to $500 per board member, not the board, for each violation, ouster from office, recall from office, court costs assessed to the person seeking enforcement of COMA, court costs assessed against the plaintiff if maintained action frivolously, not in good faith, or without reasonable basis in facts or law. So in terms of COMA issues, we get good guidance from our legal counsel. We are mindful to make sure that we are not only putting out public notice about our meetings, we do send an email out to anyone who had requested notice of information of meetings. We also put them on our website, and we also put them on the Kansas Public Square. So we are taking care of any of these issues, and if a meeting is ever canceled, we make sure that we are timely notifying people about the cancellations as well. Now shifting to the Kansas Open Records Act, or KORA. That statute requires the board to have a record open for inspection by any person unless otherwise provided, and KORA shall be liberally construed and applied to promote such policy. A public agency includes the state or any political or taxing subdivision of the state or any office, officer, agency, or instrumentality, therefore, of any entity receiving, expending, or supported in whole or in part by public funds appropriated by the state or political taxing subdivision. The term instrumentality is not defined by KORA. Nevertheless, if created by a covered entity or the group has become an extension of a covered entity, it will most likely be covered. A public agency does not necessarily include private companies, even if they do receive public funds in exchange for goods and services, judges and courts, an individual legislator or member of a governing body, private individuals, or state employees. A public record includes any recorded information, regardless of form or characteristics, which is made, maintained, or kept by, or is in the possession of any public agency, and written records, photographs, computer data, and emails. A public record does not include records that are owned by a private person or entity and are not related to functions, activities, programs, or operations funded by public funds, or records not in existence at the time of the request. The board is not required to create a record in order to fulfill a request. Under the KORA, the board must appoint a Freedom of Information officer to assist with KORA requests. And for the BSRB, that is the Assistant Director, Leslie Allen. We must display, distribute, or otherwise make available a brochure describing requester rights, agency responsibilities, and procedures for inspecting or obtaining copies of public records. We have such a policy. It's posted on our website, and it's also available if you ever come into the physical office of the BSRB. It's posted by the front desk. Additionally, the board must include the name and title of a records custodian, fees, and hours available for anyone to make a request, and that information is also included in our document. In Kansas, any person may make a request. The person need not be a resident or provide a reason for their request. The board may require the request to be in writing, state record and address of the requester, provide proof of identification, and sign a written certification that the requester will not use the names and addresses obtained for the records to solicit sales or services. Unless closed by law, the board cannot deny a person the right to review its public records. For instance, copyrighted materials may not be reproduced without the permission of the copyright holder, but must be made available for viewing or listening. If portions of a record are closed, the remainder of the record must be made available to the requester. This referred to as a redaction. The board is not required to make copies of a recorded tape or disc, videotape or film, pictures, slides, graphics, illustrations, unless shown at a public meeting. The request must be acted upon as soon as possible, but not later than the third business day following the day the request was received by the board. 3 responses are acceptable. The record is provided. in the form requested if possible. The request is under review and the record, if permitted, will follow. Or 3, the request is denied with a detailed explanation for the denial. And so just to clarify on this, it is not a requirement that we have to provide all records in 3 business days. Based on how much time it would take to research that topic and how many records might be available, we are provided additional opportunity to research to determine that, but we have to respond back in 3 business days, and we do take those very seriously and make sure we meet that requirement. Under the KORA, there's a presumption of openness. As such, the requested public records must be released unless there is an exemption or disclosure applies. The burden rests on the board to prove the requested records are exempt from disclosure, and exemptions to disclosure may be discretionary or mandatory. The KORA is a civil act, not a criminal act. And then similar to what I mentioned about violations of the COMA, the same standard basically applies. And there's additional information here, but in the interest of time, I'll move a little bit quickly through that topic. Similar to what was talked about during the COMA violation, it could include fines of up to $500 per violation imposed, and then other potential costs, but there is a viewing to see if something was denied in good faith or without a reasonable basis in law. And before we move to the CAPA, I will say this. In terms of questions that I received on the KORA, one thing I just want to stress to you are all professionals. I'm sure you've received similar trainings to this in the past, but just as a reminder, a record doesn't have to be an official document. It doesn't have to say that it's an official report of the board. Records could be something like a text message or an email. And so please be mindful, like I said, you're all professionals. I'm sure you're all aware of this, but any document that you produced in association with your membership on the advisory committee, that is something that could be made available in an open records request if it's not otherwise something that we would need to redact. So just be mindful in the way that you communicate and the different things. And so some of those records that you work with in terms of your responsibilities here could be something that might qualify under the Open Records Act. And now in terms of CAPA, the Kansas Administrative Procedures Act, or CAPA, creates only procedural rights and imposes only procedural duties. CAPA does not provide substantive law, but those laws are governed by the board's Enabling Act and Licensing Acts. The CAPA applies only to the extent that other statutes expressly provide the provisions of the CAPA govern those provisions. And so basically what this is really meaning is that in general, we will follow COMA and KORA, but when the CAPA applies, there will be information that says that certain matters will be under the CAPA. The general rule is that licensing boards like the BSRB must do business in an open meeting under the COMA unless directed by statute to conduct the proceedings of a hearing pursuant to CAPA. Those 2 acts are mutually exclusive. When a licensing board statutes provide that the CAPA applies to certain decisions, the board shall follow the CAPA, not the COMA, when making those decisions. The CAPA sets out a procedure to follow when the board is deciding what to do on cases involving individual licensees. So when we're talking about big decisions that involve all licensees or big classes of licensees, that's something for an open meeting. When we're discussing one specific applicant, that is something that would be confidential and it would be under a closed meeting in the CAPA. In those types of cases, the board is conducting a quasi-judicial function and deciding the outcome of a case. When the CAPA applies, none of the stages of a particular case have to be open to the public other than a hearing. Each of the board's licensing acts have a CAPA provision. Under the CAPA, neither the public nor an applicant has to be notified when the board meets to consider an application for licensure. Similar under the CAPA, neither the public nor the licensee has to be notified when the complaint review committee meets to consider whether probable cause exists in a discipline case or issue a summary proceeding order. Additionally, the board and the CRC do not need to take a vote in public for a decision to be under the CAPA. Under the CAPA, decisions are made when the license or an order is issued. The necessary board staff and the board's or the CRC's attorney can be present during the CAPA discussion to make sure that the board members have the information or legal advice they need to make an informed decision. A little bit more about CAPA. There are some board activities that are not covered by CAPA. These must be acted on in an open meeting under the COMA. These include approving board minutes, discussions, and votes to approve or amend regulations or guidance documents, delegating authority to a board member or to the executive director for particular action, receiving agency updates regarding the budget, legislation, statistics on complaints and CRC activity, education and the executive director's report, decisions whether to renew contracts or change the way contracted services are provided, and policy decisions affecting the way the board operates internally. In terms of applications for licensure, a person who files an application for licensure has the burden of proof. Staff gather the information submitted by the applicant for the board's consideration in determining whether the applicant is qualified for licensure or whether the license may be conditioned or restricted. If the board denies conditions or restricts a license, an applicant may request a hearing if the applicant did not agree to such action and the consent agreement in order. And then a little bit more about CAPA as it applies to investigations. The board has the burden of proof to show a licensee has violated a statute or regulation. In terms of all licensing boards, they can investigate complaints or allegations that a licensee has violated statutes or regulations. The board's investigator generally gathers information, then presents that information to the CRC. The CRC reviews the information and determines whether there's probable cause or reasonable grounds to believe that a licensee has violated specific statutes or regulations. Reasonable grounds mean information that would lead a reasonable, prudent person to believe the licensee violated one of the board statutes or regulations. When making the determination, the CRC must be sure the conduct that the licensee is accused of actually would be a violation of the statutes and regulations. The fact that the licensee did something that made someone angry, violated a professional association's ethical code, or did not follow an employee's policy does not necessarily mean the licensee violated a statute or regulation. The licensee can request a hearing on a summary proceeding order within a certain prescribed period of time. Once a petition or a request for a hearing is filed, the CAPA guides the proceedings and the hearing. If there's an immediate danger to public safety, health, or welfare, the CRC may suspend a license without giving the licensee notice or an opportunity for a hearing. The licensee may appeal an emergency order in the district court. And then the last item I'm going to cover before we end this training is the Kansas Tort Claims Act. So in general, this act governs the liability of the state of Kansas and its agencies and employees. An employee includes a member of a board or committee of a governmental entity, including elected or appointed officials and persons acting on behalf of or in service of a governmental entity or an official capacity, whether with or without compensation. The basic rule of the Tort Claims Act is that vicarious liability for any actionable wrongful act or omissions of government employees within the scope of their employment, subject to affirmative grants of immunity that may exist on a case-by-case basis. So in essence, if you are sued for an act that occurred within the scope of your members of your duties as a board member or an advisory committee member, you are entitled to have the state defend you at no cost. And then there's some information here in the slide that would basically say if you're ever informed that someone is suing you because of your membership on the board or your membership on the advisory committee, please let us know as soon as possible. There are ways that we can request legal defense from the Attorney General's office, and then we have to submit them in an appropriate format and with the appropriate time, but then they would essentially defend the state of Kansas and you under that capacity. And in terms of whether you would qualify under this, there is an Attorney General's opinion that is posted on the board's website that specifically asked this question, and it was found in the opinion that advisory committee members for the BSRB are covered under the Tort Claims Act. So I know that we're running very short on time. This is a lot of information. Please feel free to review those slides. If you do have individual questions, it may be helpful to just follow up with me by sending me an email. But I think the question that I get the most after these trainings really comes down to your role as an advisory committee member and wanting to make sure that you don't violate any of those rules I talked about, like the COMA or the CORA. And so if you do have individual questions about that, please reach out to me. I'm happy to clarify. The question that I get the most on an individual level is, I don't want to violate something. Does this mean that I can't reach out to another member of the committee if I have a question or I want to talk to them? And no, you can reach out. The real issue comes into play when you're involved with an active discussion by a majority of members of the advisory committee. So if you want to reach out to the chair with a question, if you want to reach out to another member with a question, that is perfectly okay. Just be mindful that, if you do have conversations regarding your role on the advisory committee, those communications could be deemed a record in terms of an open records request. And so just be mindful of those types of communication. And if it is helpful to have me facilitate something, like you want to provide something to the members of the committee, but you want to make sure you're not violating anything with COMA or CORA, feel free to send it to me and then ask me if I can distribute it. As an employee and an agent for the BSRB, I have some different guidance that governs my action. So I can reach out to all of you individually. And if there's information you need me to distribute, I can take care of that as well. So with that, I will end the training and I'll turn it back over to Andrea.
All right, thank you so much, David. Very helpful information for some of us that's review, but it's always good to be reminded of the different areas. And then for others, we hope you took a couple of things away from the presentation. So I know with that, we are at the top of the hour. We do have quite a bit left on our agenda. David, should we postpone the rest until the following meeting?
Yeah, I think that would be good. What I will just say is that for a few of the items that were on the agenda, discussion about changes to clinical training plans, looking at those regulations for continuing education and documentation, you already discussed those once. This was just going to be an opportunity for any additional topics. So we can talk about that briefly at the next meeting. And then also continue to review those unprofessional conduct regulations for each of the proposed changes for the other professions. It would be nice to have a good conversation about that at the next meeting to be able to see if anything that was a proposed change would be something you might want to bring over to your own profession. And so I just wanted to highlight those items to continue to review those and be ready to discuss at the next meeting.
Wonderful. All right, well, with that, our next meeting is scheduled for October, and then our next one after that is December. So with that, we will take a motion to adjourn.
I so move.
Thank you, Donna. Second,
Second.
was that Mary?
Mary.
I'm sorry. Thank you, Mary. All right, all those in favor, say aye.
Aye.
All right, any opposed to adjourning? All right, motion carries. Thank you all so much for your time today. Appreciate it, and for your work on the committee. We will see you in October.
Okay, thank you.
Thank you.
Bye.
Everyone.
Bye-bye.